All right, consideration of objections to candidate petitions for resolutions to fill vacancies. And we heard this case on the 20th, but set it over until today, Light versus Ruggieri. And I think Attorney Casson and Attorney Fogarty are both here.
That's right.
That's correct.
All right, well, Ms. Malwitz, you want to tee this up and then we'll hear from the objector?
Certainly, just give me a moment or two to
Sure.
shuffle
Take
through
your
my
time, or
papers
if
and get to
anybody
the right
need
one.
a quick break in the meeting here. We all right? Okay.
I'm prepared if you are.
No, yeah, go right ahead then, Ms. Malwitz.
Okay, this is case 20 SOEB GE 100 Light versus Ruggieri. The office is Senate 52nd State Senate. The candidate is a Republican. The objector is Jermaine Light. The attorney for the objector is Luke Casson. Attorney for candidate John Fogarty. The number of signatures that was required was 1,000, and 1,152 signatures were submitted. However, there was a large volume of signatures that could not be validated or that were stricken, leaving 949 valid signatures, which is below the 1,000 signature statutory requirement for the office.
All right, thank you, Ms. Malwitz. Mr. Casson, the objector, you can go first.
Yeah, this was, we've substantially argued this at the last meeting of the board. This was advanced to this date on the assumption that the federal court was going to rule. The federal court has not ruled on the
In the libertarian case?
Yeah. That's still in briefing. We don't have a specific ruling date set as far as I know. I haven't seen one yet. I understand that there will be one set eventually. The briefing, I believe, is all due by the 7th of August. To summarize, the objection was based on the failure to present sufficient numbers of signatures. That fact is not in dispute. The candidate responds with a constitutional argument that it is entitled to the same relief under Libertarian Party versus Pritzker as independent and new party candidates are.
All right, Mr. Fogarty? Yeah, I think you were trying to intervene in the libertarian case.
Our petition to intervene is still being decided, or it's being undertaken, being considered by Judge Norgal, and we had hoped for a ruling by this point. We don't have that ruling. Mr. Casson's framing of the case, it is correct. We have in normal times, not enough signatures. In COVID times, considering what was provided to third parties and independents, we do think we should be held to the same standard, and we would then have enough signatures. While we are waiting for the federal court, I would be grateful if, again, this could be kicked until the federal court rules one way or the other. Otherwise, either myself or Mr. Casson will be flailing away in circuit court. So the issues are framed and before you, but I think on just for the sake of judicial economy, waiting until the federal court rules would be the proper course of action.
All right, thank you, Mr. Fogarty. Thank you, Mr. Casson. Members of the board wish to be heard on this?
I don't believe, I'm sorry, go ahead, Bill.
No, I am inclined to grant Mr. Fogarty's request to hold this over to our August 20th meeting. Again, I believe that in the interests of ballot access, this is a case that's entirely different from the ones we considered at the beginning of this meeting, where the candidates, even with the lower thresholds, came nowhere close. The candidate in this case got very, very close under some very challenging circumstances. I think it would be an entirely absurd result that a candidate to fill a vacancy for an established party would have such a higher threshold than independents and third parties. I think that we should give Mr. Fogarty the time to intervene in the federal court case, to make that case to the court. Or as he said, this is just going to probably end up being litigated through the state courts under the processes that are available there. So,
Well, I agree. I don't think we lose anything by setting this over to the 20th or 21st, I believe, is our meeting. Yeah, August 21st. At which point I think we're going to have to set the ballot. So everything will have to be resolved by then. Does anybody else wish to be heard on that?
I would,
Yeah, go ahead, Senator Haney.
and I'm not suggesting that the meeting or this matter doesn't get set on the 20th, but it really is unlikely that the judge is going to finish all of the briefing and come to a ruling by the 20th, based on what we've done before. So, I mean, it would be effectively a status meeting if Judge Norval has not ruled, I presume. Is that what the board is suggesting?
I didn't get that impression.
No, I think we have to set the ballot here by the 21st, don't we? Mr. Sandoz?
Yes, Mr. Chairman, the 21st is the statutorily designated certification date.
We can't go beyond that. We have to mail ballots internationally. So one way or the other, I mean, if it's not resolved at the federal level, I think there'll be a motion that you lack your 1,000 signature threshold.
And this is the general counsel, if I may comment briefly.
Yes.
If we do not come to a ruling today, that will be preventing the parties from seeking relief in circuit court, because we will not yet have relinquished jurisdiction. So I would recommend coming to a resolution in this case today so that the parties can seek relief if that is what they choose to do.
Mr. Chairman, that's my view. I think we've heard the arguments. He didn't meet the threshold. He went down one road, and now he's stuck with it. If he preferred to make a constitutional argument, he should have done that early on. He has able counsel who could have done it for him. So I would like to move that we accept counsel's views on this and get this thing done today and let the chips fall where they may. I respect Mr. Hannigan's view, but it's close. What's the phrase? It's close, but no cigar. And this isn't horseshoes. I would just soon strike it and let the lawyers hash it out after we follow the law. The law is he didn't make the 1,000 signatures, and we follow the law.
All
And
right.
if I may be heard at this
Yes,
moment
Mr.
on,
Fogarty.
I'm not certain at all that holding over until the 21st would deprive any of the parties.
Mr. Fogarty, you're breaking up on us.
Relief in state court. Are you hearing me better now?
Yeah, it's better.
And can you start at the
Sorry
beginning,
about
Mr. Fogarty, so we can hear
missed a
you?
lot of that, John. So just
I will. It was brilliant. It was brilliant. Doggone internet. No, I don't see how waiting until your next regularly scheduled meeting, or if there is an interim meeting, is going to deprive either of the parties of ultimately pursuing this in state court if we have to. And I will say, I'll make the representation to this board. If we are not settled somehow in intervening in the suit that already has decided how COVID cases should be treated, my client's going to have to perhaps seek a different federal venue. So I see no ill effects for holding this over, and I see complication, and Mr. Casson and I, expending a lot of time and effort in state court when the federal court could be ruling at any time.
I just
Mr. Casson?
yeah.
Go ahead.
briefly, in general, I agree with Mr. Fogarty, except for one critical principle is the confluence of the production of the ballot and the appellate process will run right over one another, and somebody is going to be prejudiced by this board's delay, one way or another. There's just no way around it.
And if I may respond to that, the only person who would be prejudiced is my client, who is the candidate. And if there is objection, playing that out, if there's an objection pending, that let's say I lose and I appeal up trying to get relief, or if I win and Mr. Casson appeals up trying to get relief, my client is certified with an asterisk saying objection pending, and he's the one who suffers there, no one else. He's willing to take that on, however, in these circumstances.
So, Mr. Fogarty, what you're saying is you don't have a problem with us ruling today.
Oh, I think the better course of action is to hold this over and allow the federal court to make a decision whether they want to let us into this this case that all of these other candidates have benefited from.
But if that hasn't happened by August 21st, then you understand that we would have to make the ruling.
Oh, I understand, Member Watson, absolutely.
Mr. Haynes, what's your position?
Candice, I really believe we should make a decision today. We should listen to our counsel who says we should. I mean, once again, these are judicial inconsistencies, and we're not following the law. The Illinois statute requires 1,000 names, good names. And all these other factors are judge-made problems, and they're being argued academically. There isn't any specific order from a federal judge allowing this party to intervene. Therefore, the only thing before us is whether this candidate met 1,000 names. The answer is no. Everything else, frankly, are very good arguments by counsel. None of them apply to us and the strict meaning of Illinois law. So I prefer we make a decision and let these lawyers handle whatever they have to do as a result of that.
And Attorney Merowitz?
Go ahead, Member Watson.
Mr. Chairman, I'd like to hear from General Counsel once more time.
All right.
Certainly, and I agree wholeheartedly with Mr. Hayne. The Delgado case of the Illinois Supreme Court makes very clear that in ruling on objections, the scope of our inquiry is limited to whether the statute is satisfied. We may not look to outside matters, such as constitutional issues or estoppel issues. The board does not have jurisdiction to rule on those. Any objections of those sorts should go to the court. And by preventing the objector from going to court at this point, he's stuck in a limbo of our making. So I believe that what we need to do is vote on the objection as it is And if the parties would like to go to whichever venue of court they wish to go to, that is for them to decide.
So in other words, the facts are not in dispute that we're less than 1,000 signatures, and that's the only issue.
That is absolutely correct.
All right. Well, Member Hain, is that a motion then?
Yes, sir, it is, Mr. Chairman. I make that motion that this
All right.
jury be struck from the ballot.
Second.
All right, motion made and seconded. Discussion, Member Cadigan or others on the board that wish to be heard?
No, I, with utmost respect for my colleague, Member Hain, and our general counsel, the case law that was cited was done without a pandemic in mind. And I don't think any of us could have anticipated, and certainly the federal case law doesn't anticipate a pandemic. The current scope of the court's order as applied to those independent third parties sets exceedingly low thresholds for independent and
Yes.
third-party candidates. And it would be an absurd result for that not to apply to established candidates. I've been consistent on this position since it was first brought up that this litigation was going to move forward, that it ought to apply to established parties, and I'm not going to depart from that today, again, with utmost respect for my colleague, Member Hain, and for the opinion of our general counsel.
No, and I'm sympathetic, Member Cadigan, to think that, the Libertarians' standard's 10%. That would be what, 100 votes in this case. So we'd have nearly 10 times the minimum. But I think Member Hain made a very strong and solid argument, bolstered by our general counsel, that that's beyond us, that we have to deal with the 1,000 statutory requirement.
Right, but guiding all of our work and all the work of the courts in this area is it's the people's right to have ballot access and choice. So again, I just wanted to add that remark. If there's a motion made and seconded, I'm prepared to vote.
All right. Anybody else wish to be heard? Otherwise, roll call, Amy?
Mr. Cadigan?
No?
Ms. Donahue?
No.
Mr. Hain?
Yes.
Mr. McGuffich?
Yes.
Ms. O'Brien?
No.
Ms. Watson?
Yes.
Vice Chairman Littleberry?
No.
Chairman Schultz?
Yes. So what is it, 4-4?
Yes.
So the motion does not carry. So do we have another motion on disposing of this?
I'll make a motion that we hold the matter over until either our next regularly scheduled meeting, and the next meeting is called by the chair, to get a status report by the parties to whether or not Mr. Fogarty's candidate has been permitted to intervene.
All right. Is there a second to that motion?
Second.
All right, motion made and seconded to hold this over to the 21st. I don't know that we have any option at this point, do we, Ms. Malowitz, if the motion to strike failed?
The answer would be that the objector, essentially with a 4-4 vote, the candidate would be placed on the ballot, and it would then be for.
Well, then I withdraw my motion.
All right.
And Mr. Sandvoss, you'll confirm that?
Yes. My understanding of the past case law on that is that a motion to sustain the objection that fails would result in the candidate remaining on the ballot. It takes 5 votes for the board to take action. And in the absence of that, the status quo would prevail.
I believe that's right. So again, I withdraw my motion. I think the only thing we need to do with a 4-4 vote, Mr. Chairman, is to state a basis for our votes.
Yes, I think that's right. if this goes to circuit court, we need to make a record. I think Member Haynes stated the record eloquently. Is that adequate, Ms. Malowitz, or you want him to restate that? I think you made a good case on the record that we're required by statute since it's less than 1,000 vote minimum threshold.
Certainly, and if Mr. Hain has more to say, Member Hain, feel free.
Well, I would argue that the Delgado case is controlling. Illinois statute controls. They're both very clear. The COVID matter is something for the courts to decide. And our options here are to follow the law. We are in many ways a ministerial regulatory body. We don't have any option to go beyond what the statute says and to place people on the ballot which do not meet the threshold. That's my honest view. We are, again, we have a great deal of discretion, but not the discretion to ignore clear case law and clear statutory law. Thank you.
Thank you, Member Hain. Member Cadigan?
Yeah, just that ballot access laws are to be interpreted liberally and that bars against candidacy are to be strictly construed, and the people's right to endorse and nominate the candidate of their choice is to be broadly construed. And that I believe that if the candidate were not permitted to proceed, that would be an absurd result that isn't contemplated under the court's order. That's my basis for the vote that I cast.
Thank you. Well stated by both parties, or both sides. All right. Let's see. Is that it? Do we need to recess the State Officers Electoral Board, Ms. Malowitz?
No, are we adopting, should we adopt the reasoning and rationale for each one of our 4 votes with Mr. Haynes' reasoning and rationale so that the record is clear?
All right. Well, I will state that I agree with Mr. Haynes' reasoning. And I would say that on behalf of Member McGuffey, whose proxy I have. And you can go ahead and speak for yourself, Member Watson.
I would also like to adopt the reasoning and rationale of Member Haynes for the basis of my vote.
And I believe if he were here, Vice Chairman Linneberry would adopt my reasoning and rationale for the vote that I cast on his behalf.
And Member O'Brien and Member Donahue, go ahead.
I would adopt definitely Member Cadigan's comments for the record.
And as would I adopt Member Cadigan's comments for the record as well.
Thank you. That was Member Donahue and Member O'Brien.